Thank you, Mr. Gaffey. Ms. Sacilotto, thank you for waiting. You are recognized for up to 5 minutes.
Thank you, Chairman Mulvaney, Ranking Member Chu, and members of the subcommittee for the invitation to participate in today's hearing. You have heard firsthand from others regarding the economic impact of the 3% withholding on businesses and the enormous administrative costs the law will impose on federal, state, and local governments. I share those concerns, but my testimony today focuses on a different aspect of the problem, the disruptive and costly impact of the withholding requirement on the federal procurement system, impacts that will likely be experienced by state and local governments as well. My testimony today is mine alone and does not represent the views of my firm or any of its clients. Today, I address 3 impacts and why I believe government has the tools available already to target delinquent taxpaying contractors, making implementation of an across-the-board withholding that bears no rational relationship to past or future tax liability unnecessary. First, the 3% withholding undercuts federal policies and programs intended to assist small businesses in contracting with the federal government. These policies and programs, which I describe in my written testimony, are designed to ease the cash flow burdens on small businesses, remove barriers to entry, and otherwise promote small business participation in federal contracting. The 3% withholding requirement, however, directly undermines these policies by destabilizing cash flows. It will disproportionately harm small businesses and likely deter the innovative small businesses government is trying to attract from entering the federal marketplace at all. Second, the 3% withholding will discourage commercial item contractors from selling their products to government. Congress has enacted laws to encourage vendors of commercial items to sell their products to government so that government can take advantage of innovative, commercially available products as well as commercial pricing. Over the past decade, however, as the pendulum of regulation has swung back in favor of oversight, commercial item contractors have found themselves subject to more and more of the regulations that apply to their non-commercial counterparts, but that have no equivalent in the commercial marketplace. The 3% withholding and the cost of complying with and administering it are yet another added cost of doing business with the government. Given a choice of customers, it's entirely reasonable to believe that vendors of commercial items will decline to incur this additional cost. Government will then face reduced competition for acquisitions of commercial items, diminished access to innovative commercial products, and more than likely increased costs because the costs of dealing with the government no longer reflect the costs of the commercial marketplace. Third, there will likely be increased disputes between contractors and the government. Determining whether a contract has been materially modified such that the withholding would apply to contracts entered into prior to December 31, 2012, or if, as the IRS proposes, the government can apply the withholding to payments under any contract after January 2014, regardless whether the underlying contract includes provisions that permit such a withholding, are just 2 areas where disputes will arise. Acquisition regulations provide that if government wishes to add a new requirement or clause to an existing contract or make some other change that increases the contractor's costs, the contractor is entitled to compensation for the cost of the change. Thus, in addition to disputes that will likely arise when parties attempt to true up the withholdings, disputes will arise whether the government is even entitled to include the withholding requirement in the first instance and the cost for doing so. There are likely many more negative impacts on the procurement system that will surface if this provision is allowed to take effect. If there is good news to this story, it would be that there are existing enforcement tools making imposing this costly and burdensome requirement unnecessary. You've heard today about the IRS federal levy program that targets tax debt. This current law now permits the IRS to levy or offset up to 100% of any specified payment due to a vendor of goods or services sold or leased to the federal government. You have also heard that current regulations require contracting officers to determine whether a contractor is responsible prior to the award of any federal contract. To assist with this responsibility determination, acquisition regulations were amended in 2008 to require contractors submitting proposals to certify whether they have tax debt over $3,000. Contractors also are now required to report in a database largely available to the public, but fully available to contracting officers, civil, administrative, or criminal findings of liability or penalties over $5,000. Acquisition regulations were further amended to permit the government to suspend or debar a contractor from contracting with the government entirely for being delinquent in federal taxes. In 2010, the White House instructed the IRS and OMB to review the certifications and report whether delinquent contractors were receiving contract awards. In closing, I do not wish to diminish the seriousness of a failure to pay owed taxes, but note that the system has mechanisms in place that can target delinquent taxpayers without harming taxpaying contractors. Given these existing mechanisms, the perceived benefits of the 3% withholding are vastly outweighed by the burdens and costs the withholding will oppose. Thank you again for this opportunity to share my views, and I'm happy to address any questions you may have.